Hello, and welcome to the virtual local chairman training exercise, where we are going to be talking about how we prepare for discipline investigations. Discipline investigations are something that every local chairman must be trained for and prepared to be able to represent our members whenever workplace discipline is is in play. And this is something that's a lot of local chairmen really enjoy this part. They enjoy it because it's the discipline investigation or the formal investigation is something that puts us on level ground with the carrier and with the company. And so we're able to really show our members that they have an equal voice in the workplace, and that they do have um, the opportunity to have their day in court, be able to tell their side of the story. And ultimately, the company has the burden of proof to be able to impose discipline against our members. But while it sometimes can be a little bit of an exciting thing where you go into to the hearing to be able to kind of square off against the carrier, it also is pretty serious in that there's a lot of responsibility that comes with it. And it's certainly, it is not a court of law. We're not asking our local chairman to be Matlock or to be an attorney. We're asking them to do their very best to be able to help tell our side of the story as it relates to what happened on any particular day. Now, or I guess any particular offense is probably a better way of saying that. There's a lot of things that go into preparing for a hearing, and one of those is being able to prepare your witnesses and also being able to cross-examine company witnesses. Now, we're going to talk through a number of things, and I'm going to give you an example of one where I think that it was done pretty well, and we've got the exhibits that go with it. You may have in your mind, if you've never participated in a formal investigation, you might have in your mind like what we've seen on TV as for court or those kind of things. And it's somewhat similar, just because there's a lot of formalities, but the actual process is a lot more laid back than that. But you do have to remember, everything is being recorded. Everything is being recorded. And you'll hear me say throughout this video, and I will try to be time sensitive. I don't want to belabor any points unnecessarily, but you'll hear me say this: what matters is black marks on white paper. And what that means is that every word of testimony is being transcribed, or it's being recorded for transcription. In other words, somebody is going to take that recording and they're going to type it up into the actual words that were said. And so you want to tell your story on that transcript. And so black marks on white paper. If the hearing officer or a company witness says something to you off the record, and the transcript doesn't show it, then that doesn't really help your case that much, okay? So it's really important that we get black marks on white paper. So you'll hear me say that throughout this presentation, and that's what I'm referring to. So we're going to get started. Preparing and cross-examining witnesses, it's really important that you understand just a couple of things. First of all, let me make sure that my computer is going to cooperate with me. All right, here we go. It woke up, I guess. A couple of things just to get started. I think that there probably can be a misconception of this, but this is very self-explanatory. I think everybody will be able to fill in the blanks. Company witnesses testify for the company. Don't ever forget that. And union witnesses testify for the union. If you ever get those two things mixed up, you're going to be starting out kind of behind the barrel. You will never ever make your case through the company witness. That these are company managers, most likely. They're people that the company has prepared for this investigation, and there's inevitably a sense of pressure that they feel to, if it's a manager, to support their other manager, or their peer manager, or to support their supervisor, or whatever. So there's a pressure that comes with that. A lot of times local chairmen try their very best to go after the company witness. That's really unnecessary. And when you think about the fact that you're not going to make your case through them, I think it helps to kind of understand why we say it's unnecessary. You're going to make your case through union witnesses that you've called, that you've prepared, and that you know exactly what they're going to say to be able to tell the story that you're trying to tell. So we're going to look at how do we do that. We're going to talk about a number of things. And again, this is going to be different because normally we're doing this in a classroom setting, and I can ask questions and get feedback. And I could point to examples that somebody might be able to raise that is there in the class. And so doing this virtually is a little bit different. It's a little bit more lecturing. I get that. But in some of the Zoom breakout calls or some of the other sessions that we line up, we will certainly be able to talk through different experiences and be able to look at different examples. So we're going to look at two types of witnesses, what kind of witnesses they are, what is their role, what do they do, and when do we prepare witnesses, and then how do we prepare them. So everything is kind of built around that, and then we'll also look at cross-examining the company witness, because just like you get to prepare your witness, the company is preparing their witness. And so the company will get to cross-examine your witness, and you'll be able to cross-examine the company witnesses as well. So two types of witnesses. Who are they? Very simply, they're expert witnesses and non-expert witnesses. Now, that's really just for definition. An expert witness is very uncommon. The most common places that we would see this would be if someone's damaged equipment, they may call someone to testify that the equipment was in good working order, that the equipment couldn't have malfunctioned because of this, safety feature or whatever. So they may call a mechanic, or they may call a computer person if someone is charged with, excessive use of the internet for personal things, or using the email for personal things. They may call I've seen the company call a computer technician type or a programmer type person that would offer testimony about how damaging and compromising the personal use of email on the company system is. So it's not that common. For the most part, non-expert witnesses, that's peers, that's your coworkers. For the company side, that's going to be a manager that observed an infraction, or a manager that could talk about a process, those kind of things. It's very, very rare that we would call from the union side an expert witness. Most all of our witnesses are going to be laymen, fellow coworkers, or peers that we have prepared to help us tell our side of the story. And I think I should probably stop for just a second and say that you, as the local chairman or as the representative, you have to, before you go into a hearing and as you are preparing your witnesses, you're going to have to be working on, where am I going with this case? If the person was charged with sleeping, but he says that he wasn't asleep, or he says that, well, I'm not even sure if I might have dozed off, but man, it was the middle of the night and it was pitch black dark. There's no way in the world that I missed any assignment. I was waiting on this crew to come up. And there's no way in the world somebody would have saw me. I didn't, I didn't miss a call on the radio. There's a number of areas or a number of ways that you could argue that. You could argue that, well, yeah, he was asleep, but it was the middle of the night and he was tired. He was working, he was on a double, so he should have been able to get a power nap. You could argue that, but that's not going to be a logical. That's not going to be a logical argument. So you have to know where you're going to go with the case, and you learn where you're headed with the case by what the witnesses who you're able to prepare, and you learn what they know. You're able to kind of steer the case where it needs to go. In the sleeping example, it's the middle of the night. There's a coworker that's on the shift with me. Did you hear anyone calling the person that was accused of sleeping? Did you hear anyone calling him on the radio? Was there any work assignment that was missed? So again, if the care, and then for the carrier side, did someone observe him sleeping, or is it an assumption? Was he in a well-lit area, dark-lit area? We have to decide, or we're going to have to kind of build the case and push it in the route that we want it to go, or the path that we want it to go. And we do that, we develop that direction by what the witnesses tell us. And so they give us the explanation that we're going to be going with. So this is a real fancy definition for a witness, for the role of a witness. Intelligently relate, orally or in writing, that which he had seen or heard on a particular event that he has been through or a transaction he has been involved in. Now, I said that's a very technical definition. It really is. It's really kind of over the top. That's real fancy for saying this. A witness tells what they know. Okay? We don't really want witnesses that are just telling us what they think or what they suppose. We want people to tell us what they know. So just remember, your job is to be able to know what that witness knows and then be able to help them communicate that to make black marks on white paper. So, who are our witnesses? We're always going to have the person that's charged. That person is somebody that absolutely should know details about what's being alleged. They were there. So they're always going to be a witness. And then the other witnesses, it really is pretty broad. That's anybody that you have prepared to offer credible testimony to support the union's defense. Or in other words, anyone that you are confident is going to help you tell the story of where you're going with this case. So, it may be a crew member that, in the sleeping example, it may be a crew member that could offer testimony. No, that person was right there where he was right there ready to go when I got in the truck. He was there as the train arrived. It could be anybody that you have prepared. It could be another employee from another craft that had a conversation with your person, around the same time that they were alleged to have been sleeping. So there's a number of witnesses. It all boils down to, we only use people that we have prepared, and we only want to use people that are going to help tell the story that we're trying to tell. So the first thing is, we look at, and as in the different exercises for preparing claims and those kind of things, you're going to see, who, what, when, where, why, how. Those are the questions that need to be answered. The same with this exercise. We talked about who. Who is really anybody that you think that, or anybody that you can prepare to be able to tell the story that you need to tell, to get the black marks on the white paper to reflect the narrative that where you're going with the case. So when do we want to do that? Well, I think it's important, and you probably all know this, you want to start as soon as possible, because what happens today in 10 days may be a little bit foggy, or somebody might have cautioned them against getting involved. Sometimes coworkers are a little apprehensive to get involved. So you want to get the information while it's fresh. Get it as soon as possible. Begin that. And there's another thing that really plays to, and that is you really get on top of the case, but you also kind of gain that credibility with that member that, hey, I'm on top of things. That I'm not just waiting until the last minute and just going to go in and wing it. No. I've done my homework. I've prepared. I've done everything that I could do to prepare. So as soon as possible, I'm going to, and you always want to start with the charged employee. When that employee calls you and tells you, hey, I'm out of service, or you get that charge letter in the mail, you should in short order be picking the phone up or setting up a time in the workplace to talk to this member. What happened? Tell me what happened. Was anybody around? Did they say anything at the time? How was it handled? What were you doing? And keep notes, take notes and kind of stay on top of it. But you want to start as soon as possible. And you always start with, the charged employee. You certainly don't want to be starting third hand, where a coworker says, hey, did you hear about Joe? They caught him sleeping last night, and boy, they're really going to throw the book at him. Well, if you start there and you get this person's take on how, Joe was definitely asleep and all that, now when you come to Joe and Joe says, I wasn't asleep, you kind of, well, I talked to Jake, and Jake said that you were asleep, no question about it. That really is not a good place to start. So you want to start with the person that was charged. And most always that's the case, and it's the most practical to start with them. And then as they give you information about who else was there, what they might have saw, and you start developing that story, then you have a line of questions for what the other witnesses are going to be able to offer. But always, as soon as possible, as often as necessary. If there's if what the information one person gives you uh, kind of opens up a hole or a gap or discredits what one of the other witnesses has given you, circle back with them. Put the pieces together in your mind and in your plan so that you're not caught off guard. Again, it's kind of like building a house. You have a foundation, you have the different parts, and when something gets out of kilter, you have to address it. You want to be prepared, and you don't want any surprises when you get to the hearing and they turn the recording on. You want to know kind of where you're headed with that case. So as you talk to the person that was charged, get their information. And then the witnesses that he turns you on to, you go and you follow those lines of thinking. And anywhere that there's a discrepancy or anywhere that there's a problem, circle back and try to work through that for how that, what so that you're preparing for the loopholes that the company could try to trip you up with. So when we say when, we talked about as soon as possible. We talk about as often as necessary. But then the thing is, you always do this before the investigation. It's very, very poorly received if you show up to do a hearing and you haven't had any conversations with the person that's charged. You think about that. If you were charged with, a crime or, some type of violation, and you show up to court and you've retained an attorney, no matter how, no matter what the circumstances are, if your attorney just shows up and says, hey, or tells you, no, look, you just show up at court, I'll take care of it, you're probably not going to feel overly confident because the attorney doesn't know what's happened. They haven't taken any interest in your case. And the same here, you're the person's representative. So make sure that you're involved with this case before the investigation. Meeting 5, 10, 15 minutes before the hearing is just, it's not acceptable. You need to know where you're going with the case long before that hearing ever starts. So get started on that as soon as possible, as often as necessary. When the story changes or when the witness testimony changes, circle back, flush those things out, but always make a priority that that's done before the investigation. So how do you do it? And what are some ways? Look, I will be the first to tell you that a busy schedule is probably going to be a real pain for you in this arena, because you have to kind of coordinate your schedule with witnesses and people that work shift work and are doing different things. So and you don't want to spend much time doing this on the property because you don't want to violate a rule there. So it can be it can be a little bit challenging, but understand that it's absolutely necessary. And so we're going to talk through a couple of ways for how to do that, and then hopefully just give you some ideas. And look, as we're going through this kind of seminar format, if you have experiences or examples that you've already been through, because by the time we have our classes, we're going to be in the third quarter of the year, and normally we would be doing this in the spring, so it's probably going to be early fall when we're doing this. So there may be some examples where you've already been to a hearing. Probably will be examples. And maybe your assistant national rep or your national rep has been with you and you've seen some of the things that they've done. If you have questions about, hey, how was something done? Why do you think it was done that way? Those kind of things, jot them down. And when we get on some of our interactive calls, we'll be happy to talk through those. And I certainly want to hear your experiences and see how you think some of those things went. So what are some ways to prepare a witness? These are very basic things, but very, very practical as well. You have to know what they know about the case. You have to know what they know. Who are they? Are they a coworker? Are they somebody that was assigned to the same shift? Are they somebody that has a grudge against them? You have to kind of know the players, but then you got to know what they know. What do they have to offer? When did this happen? Why did it happen? Where were you at? Where did this happen? Where was the company officer at? What's the normal thing? Make notes about what they say and things that are important. Now, you don't have to transcribe, and I certainly don't think that you're going to get a witness to warm up to you if you, and I've had local chairmen try this, but my advice is against it. A witness is not going to warm up to you and feel comfortable in sharing, their experience if you're trying to record them. So I don't encourage you to record witnesses. I don't think that's wise. Um, Absolutely never record somebody that you don't tell them that you're recording, or at least ask them for their permission first. But I don't suggest recording witnesses, but make notes, jot down the things that they say that are of particular interest and things that you think are going to be helpful. If you need it, it's oftentimes helpful to get a statement from the witness. The company does that very well, but they can require people to write statements. See, we can't require people, so we're asking them. And sometimes people are a little hesitant to put their name in writing and get involved. But hopefully, you've kind of you have a trust, and obviously you do. Your people trust they elected you to serve in this capacity. So play on that. Look, for me to be able to do my job effectively, I need the help of people. So I'm going to ask you to write a statement if you think it's helpful. A lot of times it is, and it will just kind of give you their version and in their own words what happened. Now, there are some times where I've helped people write their statement, where I've written the statement based on what they told me and had them to sign it, and would submit that as an exhibit in a hearing, and then kind of ask questions following up along those lines. But again, that's not it's you're going to develop your own rhythm. You're going to develop your own process for how you're doing. We want to give you the bases that you got to make sure are covered. And you're never, ever going to have and prepare an effective witness if you don't know what they know about the case. So make notes from them, get statements from them if you can, or if you think it's helpful. If the witness has provided a statement to the company, you should request a copy. Now, you should request a copy from that member. And this will kind of segue into this preparing the witness part in just a second. But if the witness has provided a statement to the company, you should train your members. Not every witness is one of our members, right? So there could be, other crafts. There could be, other people that observe something. But your members that you represent, you should teach them, starting on the shop floor, starting at local lodge meetings. Hey, if you give the company a statement, you are entitled to get a copy of that. You should request a copy for your own records. And if they won't give you a copy, then let me as the local chairman know. And that way, you really aren't caught off guard. It's very frustrating as a local chairman when you have spent time preparing a case, you spent time preparing witnesses, and you've talked to them, and then you get to the hearing and you read a statement from one of your witnesses that says something that conflicts with where your story is headed. That's very frustrating, but it does happen. And so the way that you can avoid that is what they know or know what they've provided. So ask the company for a witness for a statement if you have to. Ask the member to get a copy of that statement and give it to the company. Normally, if a witness that you're trying to prepare to tell your story the way that you want to, if they have already provided a statement to the company and you don't have a copy of that statement, normally the element of surprise exists. You will find out there is some type of something that was said when it was fresh or whatever that conflicts with what you're saying. And if that member is not, if they're not willing or they're not helpful in trying to get a copy of their own statement, that should be a red flag that some of what they are telling you is going to be a little bit different than what they've told the company. So keep that in mind. If they've provided a statement to the company, you need to see that and know what it says before before you use them as your witness. So we're going to look at a couple of more things. So you have to be able to know where you're going with the case, but you also need to let the witness know where you're going with that case. Look, we're not going to say that yes, you were asleep, or no, you weren't asleep. We're going to say that you were where you were supposed to be. You were in the place that you needed to be. You didn't miss any work. Nobody was looking for you, that you weren't unaccounted for. That's kind of where we're headed. And unless the company has a picture that shows that you were asleep, or they've got two people that say, no, I witnessed him being asleep, we're going to say that in the middle of the night, in a darkly lit area, you're where you're supposed to be waiting on a crew. The record doesn't support that you were asleep. Let them know where you're going with the case. A knowledgeable witness makes a better witness. And if they're somebody that really is intent on helping you, they will make sure that the questions that get asked of them don't undermine, especially trick questions that the company asks. They'll make sure that those questions or their answers don't undermine where you're going with that. Now, there is a fine line between preparing a witness and coaching them. Your job is not to make them tell the answers you want. Your job is to get the answers that tell your side of the story. But you don't want to do that through deception. You don't want to trick people, those kind of things. Again, if you're having to trick or ask a witness to lie, that is not the witness that's going to make your story. And it's only going to make things worse. Providing false information at a hearing that's never advised, and it will just lead to other charges, and then you'll get to represent those people as well. So that's not what we want to do. As you're working through the process and preparing people, tell them or give them the questions that you plan to ask. At least the first ones. I'm going to ask you, how long have you been here? I'm going to ask you, you're familiar with the layout of the yard, correct? You've worked third shift, is that correct? You were on duty the night that Joe was charged with sleeping, is that correct? So let them know the questions that you plan to ask ahead of time. That kind of gives them that comfort level, and give them that assurance, and then start with those questions. Face-to-face rehearsal is best. Now, you can do that the day of the hearing before and let them know how it's going to work. Again, it's not as formal as a court of law. It's more formal than lunch in the shop, but it really is more laid back than formal court proceedings. But you still want to let them know. You want to prepare them so that they're not nervous and getting all freaked out. Let them know what they should expect. And some of you're going to have to learn these things as you do hearings. You'll see different procedural things. And as you start out objecting procedurally and looking at time limits and looking at charge letter specificity, all those things, which we will cover in different segments here. Let the member know that's charged. Let your witnesses know that, hey, look, I'm gonna do all of these things at the outset. Don't let that distract you. They're going to continue with the hearing, but here's how it's going to go. The hearing officer is going to ask everybody to introduce themselves. The hearing officer is going to read the record or read the charge letter into the record. The hearing officer is going to ask a few questions of everybody. Just let them know how it's going to go, because you're kind of the coach for your side, your team, and your job is to get black marks on white paper. So you have to direct the traffic and really keep your team together, and don't let them get overwhelmed with the formalities or the process. You have to let your member that's charged, but also the members that you're going to use, or the people that you're going to use as a witness, you should be upfront with them that, okay, look, I'm going to ask you this question, and I'm going to ask you this question, and here's where I'm going with the story. But you also have to let them know, or make sure they understand, the company is also going to ask you questions. And they're going to ask you questions that try to lead you into discrediting what the questions or the answers that you've given to me. That's cross-examination. And we see a lot of that in the court world. And more as a good defense attorney is able to ask questions in a way that provides, that discredits the state's evidence. Well, the same thing is going to happen where you're cross-examining the company's witness and the company is cross-examining your witness. There is going to be an effort to undermine what we're saying. So remember, we start as soon as possible, finding out what they know, letting them know where we're headed with the story based on the information that we've had. We do that before the hearing. We're if witness A tells me something and witness B tells me something that's pretty close to the same thing that witness A said, but there's a little bit of a discrepancy, I want to go back and clear that up. And I want to make sure that my witness A and my witness B and my witness C, that they're all telling the same story, not from a script, but that the answers to their questions are in line with the story and the direction that I'm headed with this case. So I've done all that prep work. I've talked to the person that's charged as soon as it happens. I've talked to them and I've asked them to give me a copy of their statement. If they wouldn't give it to me, I've asked the company for a copy of their statement. I've asked the people, the eyewitnesses that were there. I've asked the people that were familiar with the process. I've asked for people that were, whatever the nature of the charge is. I've talked to all these people. Well, good preparation is key, but then we have to take it to the next step. We've got to go and make black marks on white paper. We have to get it on the record. We've got to tell our story on the recording so that it comes out when it's transcribed. So as we get it on the record, try as best you can, ask the questions that you rehearsed first, the questions that you prepared for them. Ask questions that allow for short answers. You'll notice in the example that I use here in just a little bit, the actual physical example, and then you'll also notice that when I give an example in these videos or in these tutorials or even in our interactive sessions, my questions are always going to be, is that correct? Yes. Or is that true? I do those things intentionally because number one, it's easier. It's easier if you just say correct. That way you can prepare a member to just say, to the extent possible, if you hear me say correct, you say correct or you say yes. That's a lot. I mean, that's very, very easy to try to help prepare them. But then when you do that, you have to be creative and be able to kind of think a little bit quickly to ask the questions in that format. So, and a lot of that will come with experience. And unfortunately, some of you will get more experience than others. And that means to get experience in this arena means your members are being charged. And, but as you get experience, you'll be able to learn from that and kind of build you'll develop your method of operation for how you do those things. Ask questions that allow for short answers. The reason we say that is people, when they get to talking, generally they get a little bit nervous, they get a little bit rambling, and they start talking about things that aren't relevant. Well, once they talk about something that's, whether it's relevant or not, if it's your witness, you're going to have a hard time stopping them. But if they get to talking about things that aren't that relevant, then what happens is it now gives the opportunity for the company to come back and start cross-examining them and talking about those things. So let's move on here. Don't ask questions which you don't know the answer. It's dangerous. You have to know either the answer that the person's going to give for sure because you've prepared them on it, or you have to know the actual fact, the factual answer for the question that you're asking, so that if the witness gives an incorrect answer, you're going to have to be able to prove that answer is wrong. It's just not worth the risk. If you don't know the answer, don't ask the question. It's not worth the risk. And I could give you tons of examples of that in my own experience and then reading other transcripts of local chairmen as well. No matter what, always, 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 your witness should tell the truth. Lying, again, if we're having to get people to lie, that's not our witness. But also, along those lines, we don't have to encourage people to tell everything they know either. The company's job is to prove that somebody violated a rule, and the company pays its managers to do that. So we don't have to encourage our members to go and be the tattletales of the police or the extension of managers. in the workplace. So, but again, you should not encourage people to lie. What happens is they get caught up in it. You discredit your witness, you ruin your credibility with the company, and then ultimately somebody gets charged for providing false information. And now you've got to go represent somebody for providing false information related to something that you encourage them to provide false information for. It's really, really, really sticky. It's just not advised. Tell the truth. So we follow back up with that. They should tell the truth. These are just kind of tactical things. A 5-second rule. Normally, if I'm the person that's representing the member, I'm going to tell that member or my witness any question that when you get asked a question, especially as it relates to cross-examination. So you've asked your questions, and you're going to, at some point, you're going to say, I have no further questions. Well, the company is then going to turn to the hearing officer is going to be able to ask questions of your witness. And he can ask questions that's called the cross-examination. And he can ask the questions that tries to, downplay the story that you're telling. It tries to downplay what you're doing. You don't. That's okay. Cross-examination is cross-examination, and just as important as your witness telling the truth when you ask a question, our witnesses should always tell the truth when the company asks a question as well. Again, we should not be in the habit of encouraging people to lie. It doesn't help anything. But what I often tell people is, hey, look, when the hearing officer asks you a question, give it a few seconds before you answer. Take a deep breath. Give it a few seconds. You don't have to be in a hurry. And what that does is, if I, as the representative, if I hear a question that I think is leading or whatever, I think it's repetitive, it gives me the opportunity to object to the question. Objection, Mr. Hearing Officer, you've already asked that question. He's answered it. And the hearing officer may say, well, Mr. Hollis, with all due respect, I'm asking the questions and I'm asking him to answer it. And then I could say, well, with all due respect, he's already answered that. And the answer was yes. I'm asking you to please move on. Now, the hearing officer probably won't sustain my objection, but the witness has heard the answer that I want him to give. Yes. Or, Mr. Hearing Officer, he has already answered the question and said that he wasn't sure. I'm asking you to move on. And the hearing officer may overrule my objection, but the member has heard, or the witness has heard, the answer that I'm looking for him to give that tells our side of the story. So again, that's just a strategy that you'll develop. But remember, you don't have to be in a hurry. You don't have to be in a hurry. There's no award for who finishes fastest. What matters is black marks on white paper. Does that transcript tell the story that we need it to tell? You're going to, when you're asking questions to the witness, you're going to ask them short questions, right? You're going to ask them questions that say, correct? Is that right? Is that true? You're going to ask the short questions that don't require them to go on some narrative. You have to know that the company's not going to do that unless they're setting them up for the answer they want. They're going to ask questions that are leading. Well, would you tell us what you know about the date in question? Well, I could tell you, there's a lot of things. Well, I stopped at McDonald's for breakfast. What do you want to know? And so if the company asks those leading questions, you should do two things. You should tell your witness to try to be as short and succinct as possible, just like they were in the answers that they provided to you. But then if it gets to where it's too leading, you could even object to that question and say, objection, Mr. Hearing Officer, that's a leading question. Objection, Mr. Hearing Officer, that's a very broad question. Objection, Mr. Hearing Officer, that's a question that's requiring speculation or supposition. And though you're asking the member to guess. We're here to gather facts, not opinions. So those are things that you'll watch out for. And again, you'll develop your own style and you'll gain some of that with experience. But prepare your witness. Give them the questions that allow short answers when you're asking the questions. And then when the company's cross-examining them, prepare them to try to give short, concise answers as much as possible. And then always arm them with the fact of this. If they're not sure, it's better than making it up or not saying I'm not sure or I don't know. That's better than making up an answer. Again, if you make things up, it's never going to help us. If you encourage people to lie, it's never going to help your case. So it's okay if they say I don't know. So as we look at cross-examination, where you're going to your witness is going to be cross-examined. Again, they should tell the truth. Again, they should try to be as concise as possible. If they don't know, they don't know. There's processes that are in place. But now we're going to talk about you cross-examining a company witness. So the hearing officer gets to cross-examine your witness. You get to cross-examine the company witness. And you have to be prepared to do so. Now, you don't know everything that the company knows until you get to the hearing, unless your agreement has right of discovery. Most of our agreements don't have right of discovery. And so when you get to the hearing, you start seeing all of this evidence and you hear the testimony of the charging officer. You hear the testimony of the witness, and the company always goes first. They have the burden of proof, so they are required to go first. And so you hear what the company has, the evidence that they have. Well, just like when you were interviewing your witness, you took notes. When you're hearing the company a witness give their testimony, take notes. What did they say that's different than what your person says? Take notes. Now, so when it comes to cross-examination, same thing, kind of making sure that we're answering the questions. Who, what, when, where, why, how. How do we do these things? Every witness that offers testimony from the company, you should cross-examine them. Now, you may not have to cross-examine all of them as thoroughly. If a company witness comes out there and says, hey, look, I was on duty that time. I'm here to enter an exhibit that shows that Joe was on duty on April 1st, and he was on duty from 2300 to 0700, and here's his payroll record. So I'm the payroll manager, and I can confirm that he was on duty. Well, you probably don't have to. Ask that person a ton of information. There may be a question that you ask about the document. Where does it show in the document? What does this particular line item meet in the document? So every carrier witness doesn't get the same level of cross-examination, but there's more than likely there's going to be questions that you can ask of any carrier officer. Now, remember, you're not going to make your case through the company witness. They are there for a purpose, and that purpose is they're there to tell the company's side of the story. So remember, ask the questions that help tell your side of the story, not your side of the story, that helps tell that helps take the story or the case where you're going with it. So don't try to trick them. Don't try to trip them up. You can try, but they're usually pretty good at this. They've been trained as well. So we don't really have the chance to train our members or our witnesses like we can train our local chairman. With a company, they train their managers for this. So keep that in mind. Why? What is kind of the goal there? And I put it here on the screen, but I'll just say, every company witness is there for a reason. And what you want to do is you want to try to mitigate or downplay the impact of their testimony. You're not there to call them a liar. You're not there to, make them sound stupid. If you can do those things diplomatically, great. But, the real point is that you want to minimize their testimony. Every testimony, both ours and the carriers, there's always some holes in it because nobody is with somebody every waking hour of the moment. There's always going to be holes in what they saw, what they thought they saw, what they heard, what might have. There's always going to be some type of discrepancy. So what we're really trying to do in our cross-examination is we're trying to pinpoint those, point them out where what our witness says is different, and where what our witness says is, where what our witness says is different, why our witness's version is more believable. It's more practical. There is another explanation. Joe wasn't asleep. Joe perhaps had his head in the reclined position, but that wasn't asleep. And when you consider the fact that he didn't miss any work assignment and he was where he was supposed to be, no one was looking for him on the radio. When you consider all of those things, it's more likely than not Joe wasn't asleep, even if his head was in the reclined position. So again, it's trying to identify the discrepancies and then expand those a little bit. You don't want to go too far because you start sounding unbelievable, but you expand those a little bit to again try to make the story line up with where you're headed and tell. You want the black marks on the white paper to tell your version of where you're going with the case. Again, you're not trying to deceive you. You're not trying to change history. You're not trying to make things up. You're providing explanations for how this could have happened and why this could have happened. And are you're really trying to get at, not badgering them, not pestering them. You're really trying to get at that. So here's a chart. Okay, how do you do this? So when you're going to ask a question in cross-examination, this is a flow chart. It's in Schoology. You can have it, but it really is pretty self-explanatory. Okay, ask yourself these questions. Do you know the answer? When you're going to ask a question in cross-examination, I'm going to ask this manager, were you on duty on the night of the incident? Well, if I know that he wasn't on duty, well, I'm going to ask this question. I'm going to ask this question because now I know that he's not offering firsthand information. He's offering second or third hand testimony, and I'm going to try to use that to discredit it. Well, if he says, yes, absolutely, I was on duty, and I know that he is, or he's already given me that testimony, okay, I know the answer to the question. So now I have to, but if I'm not sure, if I don't know the answer to the question, I'm not going to ask the question. Now, that doesn't mean that I can't ask the question eventually. I could take a recess and I could ask the person that was charged. I could ask the other witnesses, hey, do you know if Trainmaster, whatever his name is, was on duty that night? And now I know the answer to that question, so then it can kind of get me back to this thing. Do you know what the witness is likely to say? If I'm going to ask a question about, did Joe miss any work? Was there a work opportunity or an assignment that was not done because Joe was alleged to have been sleeping? Well, if I don't know what that witness is going to say, now I may know the answer. I know the answer, and the answer is no. Joe didn't, because I've got all the information from Joe, and I've got other witnesses, but I'm probably not going to ask the company that question because I don't know what that witness is going to say. I don't know what Trainmaster A is going to say about that question. So I'm not going to ask it. And then the third thing is, will the answer help my case? So even if I know the answer and I know what they're going to say, if it's still not going to help me, I'm not going to ask the question. So the questions that I'm going to ask are the questions that I'm reasonably sure I know the answer, that I'm reasonably sure I know what the witness is going to say, and that I think this is going to help tell the story that I'm trying to tell. I don't need any extra questions. No your assistant national reps, your national reps, your VPs, the arbitrators, no one needs to read a bunch of extra nonsense questions. The questions that you ask should be designed to get the black marks on the white paper to tell the story that you're trying to tell. So again, this is a flow chart. It's in Schoology. It's very practical. You know the answer? Great. Think about it. What's the witness likely to say? Okay, let's say they say that. Is that going to help me? Absolutely. Go ahead. Not sure the answer. I'm stopping. I know the answer factually. I know what the actual legitimate answer to the question is. Great. But I'm not sure what that witness is going to say. Don't ask the question. Well, no, I know the answer. I know what they're going to say. I know what they're like. I mean, I know what is the only logical answer for them to give is yes. But does that matter? No. Well, then stop. Don't ask the question. So that's just something that will help you kind of filter your questions. So the only questions that come down in this green box of ask the question are ones that you've vetted through that process, and they're helpful in you reaching your goal. So how do we do it? How does this, again, just like you've prepared your witnesses and then you've got to transition it into black marks on white paper by getting it on the record, you got to do the same thing in cross-examination. You've taken notes while the charging officer and while the witnesses are testifying. You've taken notes. You've pointed things out in your own mind. You've taken a recess and you've talked to your witness. You've talked to the other witnesses and you've kind of compared notes. You've got to go and get it on the record. So we're going to listen carefully to their testimony. What do they say that differs from our witness? What do they say that differs from the charge letter? Now, see, that's important. See, Joe could have been charged with sleeping. Joe could have been charged with being in a position conducive to sleeping. Now, those are two different things. You see, if Joe is charged with sleeping, and we can point out more than likely Joe was not asleep because he was where he was supposed to be. Nobody was looking for him. He had answered the radio to get to that location. He was in the place where the crew needed him when he got there. It was dark. It's the middle of the night. Joe's where he's supposed to be. How can you assume that Joe was sleeping when there wasn't the charging officer may say, well, when I walked by or when I drove by, Joe's head was tilted back. Well, if the specific wording of the charge letter says you were sleeping, more than likely Joe was not asleep. But if the specific wording of the charge letter was your head was tilted back and you were in the position of sleeping, well, now we have to ask questions about, how far away were you? What's the lighting scenario? Was it really possible to even see? And again, it comes back down to since you weren't right there, you don't have a picture for evidence. It's still more likely than not that Joe wasn't sleeping. So the specific wording of the charge letter matters, and it'll help you kind of frame those questions. But what the company officer says, like for instance, if in our example of Joe who's charged with sleeping, if Joe is charged with sleeping, if there's nothing in the charge letter that says you were charged with your head being tilted back in the position of sleep, and the charging officer only talks about he saw his head tilted back, well, we would ask a question. I've read the charge letter, Exhibit A, and the charge letter does not mention a position of sleep. Is that correct? Now we've cross-examined him, and that his testimony is different from what the actual charge letter is. So, and once we get the answer, we stop. But again, that's just an example. But remember, all of these things are going to, it's a case-by-case basis. You're hearing where a guy is charged with sleeping. You're hearing where a guy is charged with stealing. You're hearing where a guy's got an attendance violation. All of those things every case is going to have a life of its own. But the boxes that you check and work through what bases you cover, those are going to be the same. You're going to prepare your witness. They're going to be cross-examined. The company is going to prepare their witnesses, and you're going to cross-examine them. And the way that you prepare your witness is the same way you prepare yourself for cross-examination. What do they know about the case? Take notes. What do they say that's different from what my people say? What do they say that's different from the charge letter? And again, there is no award for finishing fastest. So you can take a recess, talk through it with your witness, talk through those things, and review the questions with the principal or the claimant or the other witnesses. Again, to the extent that you can, you don't want to ask open-ended questions, but it's okay to ask leading questions. Do you just suppose that Joe was asleep? Or a better way to ask that question is, so your testimony is that you just assumed that Joe was asleep, correct? Now that's a very leading question, but it's a very short question. You see, it asks the question, yes, and I'm trying to say it in a way, or the answer is yes, it tells the story that I want. More than likely wasn't asleep, you're just basing it on your assumption. But I don't know, based on the testimony, I don't know what this train master is going to say. He may say, well, no, it's not my assumption. Oh, okay. But your testimony was that you were driving by and you just happened and you were just driving by. Is that correct? Correct. And your testimony was that it was in the middle of the night. Is that correct? Correct. And the witnesses have testified that there's not a lot of lighting in that area. Is that correct? That's correct. Okay. Now, what I've just done And again, I know my examples are perfect scenarios because we're not in real life, right? But what I've just done is I've asked the questions that the manager says, no, it's not my assumption. Okay, but again, you're driving by middle of the night and it's poorly lit. And then we could also point out that there was no work that was missed. No one was looking for Joe on the radio. He was where he was supposed to be. So now again, it kind of tells my side of the story. More than likely, Joe wasn't asleep. And when you look at all the factors, those are going to play into what the totality of the record is. And again, I know it's hard to it. I'm probably making it sound easy. More times than not, when a person is charged, they did do to some degree what they were alleged of doing. The company doesn't really make a habit of just blindly charging people, but there's always another side of the story, and it's usually not to the degree that the company has alleged that it is, and it's not as serious a violation as the company has alleged that it is. So, or it's not as obvious a violation. So, again, some of these things will come with time, but you want to try to be brief. You don't want to give them the opportunity to just go on and on and on, because what happens is they um, they start repeating their testimony, and now that's another time that on the transcript it tells the company's side of the story. We don't want that. We want brief questions, but they can be leading. They can be leading in that um, you're trying to stretch it a little bit to make their answers mix up with your narrative. But again, remember, you don't ask a question you don't know the answer to, and also remember, you're not going to make your case to the company's witnesses. Okay, they're not going to do that. And then don't argue with them. Don't make it sound like you're trying to be combative. Those kind of things. You can be stern. You can be just as stern as they are with you, but you don't want to get into an argumentative shouting match. Those kind of things. It's just not helpful. And then once you've got the answer you want, move on. Okay, thank you. Next question. And now the hearing officer may stop you and say, "Hey, listen, Mr. Union Representative, you're going to have to let him answer the question." My answer to that is always, absolutely. He answered the question. Now we're moving on. And then because you don't want that, you don't want them to continue to expound on things, because again, they're gonna circle back to telling their narrative and their story. So remember that. Know when to stop. One question too many can really mess your case up. It can throw a lot of it can kind of sew up every loophole that you've established. So know when to stop. When you've got the answer you need, or when you've made the point you want, stop. It's so easy for us to come back to and try to jab them again, but know when to stop. It's very important. Um, the I want to show you an example. So we're at the end of our PowerPoint, but I'm going to show you an example of where a local chairman did this very effectively, and I think that it'll be a helpful exercise for you. So I'm going to have to switch screens here, so bear with me. All right, so this was on CSX. This was back in 2012. So now there's a number of examples that we could give, but this one's really concise, and so we're able to use it. This was an intermodal employee who was working in a clerical function, and they were doing the gate inventory, and so they were responsible for verifying the information on the chassis and containers that go out the gate. Now, if you work in the intermodal world, this is probably pretty familiar terminology. If you don't work in the intermodal world, I'll give you the kind of the dumbed down version. So the containers that are come on the rail and then are transloaded onto trucks, or maybe get here on ships, get to the terminals by rail, and then are kind of divided up and put on chassis. 18 or trucks drive them down the road to the Walmarts, to the Amazons, to the Costco's, to the TJ Maxx, you name it. So those containers, they get to the terminal on rail, or here they did, and then they are loaded onto a truck, and that truck would take them to the customer. Well, This particular individual was charged with improper workmanship. Notice that there, improper workmanship in violation of standard operating procedures. Now, the local chairman here is named John Bailey. John's a good local chairman, been around for a long time. And John does a good job at this hearing. He has prepared witnesses, a number of witnesses that would give that could tell his side of the story. So I'm going to try to condense it and tell you where John was going with the story. There is no question that, well, let's go back up to the charge letter. See, what happened was this container, DFSU 233658, actually did go out of the gate incorrectly. So the customer got the wrong container. That happened. That really was a problem. No customer wants to get the wrong container. That really was a problem. That really did happen. So our argument is not that the container never went out the gate incorrectly. Our argument is not that the container was on the incorrect chassis. That was not our case at all. What John did with the case was he argued that what this person did was not improper workmanship, and it was not a violation of standard operating procedures. Yes, the container went out the gate the wrong way, but what happened was completely normal and acceptable at this location, and there was no rule that was violated. It was unfortunate, and there was no rule. So what John does is our local chairman Bailey has a number of witnesses that are going to offer testimony. Notice his questions. Is this a pretty common occurrence? Well, he knows the answer. He works there. He's very familiar with it, but he's prepared his witnesses. The witness says, yes. He asks the next question. Are you familiar with the outbound gate procedures? Well, Mr. Bailey knows that his witness has worked there, but he's also prepared him. And so you've worked it yourself, firsthand testimony. It's been put into the record that our gate lanes, we have 3 outbound gate lanes. Is that correct? Correct. Notice the way that the local chairman asked the questions. He's asking the questions in a way that the only answer that can be given is consistent with his story. Now, here's the story. Again, we're not arguing that the container didn't get out the gate wrong. We're arguing that it was not the employee's fault. So they have three lanes of traffic. The first lane, lane 1, is the one closest to the building where the clerk is sitting. Lane 2 is the middle. Lane 3 is the outside. Well, when something is in lane 1 or lane 2, you cannot see lane 3. And there is no requirement for the clerk to physically verify with his own eyes the chassis number and the container number. If the information that the driver gives shows a match in the company's system, then that showed as an automatic verification. Now, if the driver gives incorrect information, or if the information the driver gives isn't matching up in the computer system, then a physical inspection is necessary. So what happens is the driver goes to lane 3, the clerk can't see lane 3, so he takes the information the driver gives, it matches up in the system, and he's allowed to leave. Turns out the driver gave wrong information, and it did not, so the system approved it inappropriately. But again, remember, the wrong container did leave, and it did get out. So what's the company trying to do? They're trying to blame it on who's at fault. Instead of let's fix it, who do we blame? And so they're blaming our member, and the local chairman is pointing this out. So he's telling the story, painting the picture. There's 3 lanes, just like I'm doing for you. 3 lanes, correct? Correct. If something's in the first gate lane, you can't see lane 2 and 3. Is that correct? Again, normal questions, but asking them in the way that he wants them asked. Have you noticed that whether it's common or not for the gate clerk to go outside if they can't see lane 2 and lane 3? Or do they normally make the move from inside? To my knowledge, they normally make the move from inside. Looking at the association or the event screen, and you're familiar with the event screen, you see these on a regular basis. Is that correct? Correct. So that's where that's what I was talking about. What the clerk is looking at is when he puts the information that the driver gives, it's going to show a good association that chassis belongs with that container, and so it's acceptable. So I don't know why my screen's going blue here. So we come down. He's got another witness now, Mr. Osborne. Have you spent a lot of time working the gates? Yes. Are you familiar with the outbound gate procedures? Again, he knows these questions. Yes, I am. 3 lanes, correct? If there's a truck parked in 1 and 2, or lane 3 visible. If there's a 50-foot or a 53-footer or a 40-footer, there's generally that you cannot see it beyond that first lane. Do you know if it's common procedure if trucks are in all 3 lanes? Do you have to go out and actually verify the numbers? Osborne, no, we don't have to. So again, he's telling the story, and he's using another witness to tell the same story. And he's asking him a little bit different questions, but for the same story. And again, everything's headed where we're going. Now, Osborne is, so you ask him, instead of asking about the association or the event screen, is there an instance that would flag you to go outside? Well, Osborne's going to tell him that, hey, look, if there's a problem or a discrepancy, that the driver alerts you to something, or if there's an issue with that association, then you would go out there and do the verification. So again, the local chairman here does a great job telling his version of the story. The company, all they were saying in their testimony was a container left the gate and got to the customer. It was the wrong container. That's not a good thing. We're not suggesting that we want customers inconvenienced, but that doesn't mean that our person violated a standard operating procedure or that our person was improper in their workmanship. They did what was normal. The information that the driver gave was a good association in their system. The driver was cleared to leave. Turns out that the information the driver gave was incorrect. Now, it's important that that we see this all the way through. And then I would also point out the company in their testimony never produces one standard operating procedure. They don't produce anything. So local Chairman Bailey knows that they don't have that because they didn't produce it. So he does ask some questions in his cross-examination about that. But for the sake of this exercise, I really just wanted to show about how he's handling his witnesses to tell his version of the story. So here's the results. This is an excerpt, and the more complete document, we can put that in Schoology so that you can see. Usually when we're doing an in-person session, I would hand these out as exhibits and we would go through them. But I highlighted this part. Now the arbitrator has never worked for CSX Intermodal. The arbitrator has never been an ISR or a union rep or any of those things. The arbitrator is an arbitrator. They're looking at the facts. They're reading our black marks on white paper, and here's what she came up with. Claimants, the highlighted part, claimants' actions and method of outgating container, DFSU 233658, we know it got out in error, but here's what the arbitrator found, that those actions were consistent with the company's standard operating procedures and therefore appropriate. A host of witnesses testified regarding the routine procedures for outgating containers. Among the steps is the responsibility of the driver to communicate with the ISR and to correctly identify the container and chassis number with which they are leaving the terminal. In the event the information provided by the driver matches the company's record, the driver is cleared to leave the property. So she goes on to sustain our award. This gentleman got a pretty lengthy suspension for this failure, but not because this one alone, but where he was at in progressive discipline. And so we were able to get that overturned. And again, it's us, black marks on white paper, telling our side of the story. So now, unfortunately, even in my own experience, I could give you a number of examples of where, one question too many, not asking the right questions really didn't help us, or trying to make our case out of people and with people that were either company witnesses or witnesses that didn't want to be involved, and it was not helpful. So we're at the end of this video, and I want you to, I hope that it's been helpful. As you've went through this, you're free to go back through it, but as you watch that, jot down questions that you have. And as we set up the interactive sessions, I'm curious, I want to hear the experiences and the examples that you have to talk through. And I hope that this has been helpful. And I look forward to engaging, to meeting you first of all, but then also look forward to our interactive sessions where we're able to go through examples and the questions, specific questions that you might have about this. Hope that you have a good day and look forward to talking with you soon.